Hello, I'd like to talk to you today about a charity insolvency case, and it's the Wedgwood case. Here is a piece of Wedgwood pottery for you to gaze upon, which will remind you of that famous potter Josiah Wedgwood in Etruria, his Staffordshire-based pottery, working away there in the 18th century, coming up with new designs and techniques for pottery. But Wedgwood is important for us because it helps move on the story of charity insolvency away from cases like Liverpool Heart, and brings us up to date with a charitable company that is going through the administration procedure. And all the questions that raises for His Honour Judge Pearl QC as the judge when he's considering the respective interests of stakeholders, such as, of course, the creditors on the one hand, and the broader idea of charitable purpose on the other. Because, of course, if this is a charitable company, it has as its objects a general charitable purpose. And if those two things come into conflict, namely creditor interests and general charitable purpose, what is the resolution? Who wins out? Well, let's think about the case. So, Wedgwood Museum Trust Ltd in administration, citation 2013, square brackets, BCC 281. Highlights a number of important issues relating to insolvent charities, not least the potential availability of different procedures for dealing with insolvent charities in England and Wales, as well as other jurisdictions, as well as specific issues such as the company's assets being used to fund pension deficits. The whole saga at Wedgwood grew out of the 2009 insolvency of the Wedgwood Group of companies. The group included a trading company, which was called Josiah Wedgwood and Sons Limited, and a museum company, the Wedgwood Museum Trust Ltd. Importantly, His Honour Judge Pearl QC had to consider whether the company held property on a charitable trust, that's the Wedgwood Museum Trust Ltd, or in the alternative, if that company held the gifted property for the benefit of the costs, charges and expenses of the administration, and the liabilities of the museum company to its creditors, and some 134.7 million pension deficit liabilities rested on the answer to that question. As the museum company was the last surviving company in the group, it was liable for the pension liabilities pursuant to Section 75 of the Pension Act 1995. The museum company was incorporated in 1962, and the collection was gifted to the museum company in 1964. The motivation for this transfer from a trading company within the Wedgwood Group was to protect the collection from adverse trading activities. Presumably, this would include ultimately exposure to creditors, particularly those of the trading company, but also creditors more generally, including those of the museum company. In devising this corporate structure, there would be a permanent inalienable collection. Further donations were made by Dr. Rayform Williams and the Wedgwood family members. And as His Honour Judge Pearl QC notes in his judgment, the collection is a unique collection of pottery and other artefacts and items of historical importance, built up over many decades. The collection was valued at between 11.5 and 18 million. The 1964 deed poll activating the gift did not mention a charitable trust. The museum company was identified as a beneficiary. As noted, the insolvency occurred in 2009. The museum company was placed in administration. Well, the Attorney General argued that the museum company held the 1964 gift on charitable trust for charitable purposes. Whereas, of course, the pension fund trustee argued that the company owned the collection in law and had done so since the 1964 transfer. Accordingly, the collection was available for the company's creditors pursuant to the insolvency legislation. His Honour Judge Pearl QC held that the assets were those of the museum company and that they were not held on charitable trust. The assets were therefore available for the company's creditors, including the pension fund, across the whole of the Wedgwood group of companies. This meant that the museum collection could potentially be broken up and sold to the four corners of the globe in order to satisfy the pension deficit and creditors. Indeed, His Honour Judge Pearl QC reflected on this when he observed in his judgment, quote, "This is a sad conclusion for those who are concerned to preserve a collection which is part of our cultural heritage and of immense importance, but it is the combined result of the pension protection and insolvency legislation." Close quote. However, of course, there is a counterbalancing argument, and one to which His Honour Judge Pearl QC paid heed. He observed, "It is at least a legitimate view that the tragedy that befalls working people when their pensions are affected by insolvency is at least as great as the tragedy that has befallen or may now befall the collection in this case." So the Wedgwood case then is a logical progression of the earlier first instance judgments in cases like Re Vernon's Will Trust, Liverpool and District Hospital for Diseases of the Heart, and the Re Arms decision. However, is it correct when viewed through a prism of general charitable purposes? So the fact that the legal device of separate corporate personality was deployed but then subsequently overridden within the group's structure by the Pension Act provisions, had a radical effect on the charitable activity that was being undertaken by this separate legal entity. And perhaps it's just the naivety of the original 1964 solicitors in not envisaging the subsequent statutory intervention would have the opposite effect of them hiving off assets into a separate vehicle. In the end, of course, you'll know that all was not lost in terms of the collection, because it was bought out essentially by the Victoria and Albert Museum through various intermediaries. So it's now owned outright by that museum and loaned on a permanent basis to the Wedgwood Museum in Staffordshire. Do go along to the museum if you have a chance, and you'll see also the pottery still working in practice, so you can see both aspects of the case there, the trading arm and then the museum arm, and look at the lovely pottery as developed originally by Josiah Wedgwood. So that's the Wedgwood case. So from me for now, goodbye.